So, welcome to ME-Arcone Queing, a podcast initiative by the Institute for Alternate Dispute Resolution in New Delhi. Here we explore how conflicts can be resolved smarter through mediation, arbitration, negotiation, and other people-centered approaches that save time, reduce costs, and preserve relationships. If you've been enjoying this conversation, take a moment to leave us a comment. We genuinely love hearing your thoughts and perspectives. This space grows because of you, and if you know someone curious about arbitration, mediation, or the minds shaping the area landscape, share this episode with them. My name is Shubhi Dewangan. I'm a second year law student from Symbiosis Law School, Nagpur, and an intern at the Institute for Alternate Dispute Resolution. It is a pleasure to be your host for today's episode. At ME-Arcone Queing, our mission is clear: to reduce the heavy reliance on litigation by championing peaceful, efficient, and collaborative dispute resolution. While courts are essential to deliver justice, they are frequently overburdened with conflicts that do not require a courtroom battle. Alternate dispute resolution through mediation, arbitration, conciliation, and negotiation provides a powerful alternative. ADR goes beyond merely saving time and money. It preserves human relationships, encourages meaningful dialogue, and puts the power of resolution back into the hands of parties involved. More importantly, by diverting resolvable conflicts away from the courts, ADR enables the judiciary to dedicate its attention to the complex cases that demand it. Our platform is built to spark dialogue, raise awareness, and establish ADR as a premier choice for dispute resolution. Because at the end of the day, ADR isn't just about settling disputes, it's about rethinking how justice works. For today's special episode, we could not have asked for a better guest to guide us this conversation. Joining us is Ujjwal Sharma, an advocate, arbitrator, and the co-founder of Sharma Kemp Chambers. Mr. Ujjwal Sharma, sir, brings a truly cross-border perspective to dispute resolution. As a member of the Chartered Institute of Arbitrators, his practice spans from both India and the United Kingdom, where he has worked extensively as a commercial litigator. His expertise covers a complex cross-section of fields including commercial, military, public, and environmental law. Notably, he has litigated several high-profile public law matters in India and was recently asked by the National Green Tribunal to suggest measures for tackling climate change-induced crop contamination. His academic foundation is just as vigorous. Mr. Ujjwal Sharma sir holds an LLM from King's College London, a BLLB honours from OP Jindal Global University, and has studied international law, public policy, and human rights at the University of Oxford. Whether he is navigating intricate commercial arbitration or addressing systematic environmental challenges, his insights into the evolving legal landscapes are incredibly valuable. Welcome, sir, to the show.
Thank you so much for that lovely introduction and for the kind words. I'm really glad to be here and glad to be contributing to this conversation.
Thank you, sir. Now, my first question for you is, having practiced both in UK and India, how do cultural differences alter the way parties communicate and find common ground during your mediation?
Right. So, one of the most common or rather important lessons from practicing both in the UK and in India is that conflict is universal. It is going to happen, right? As much as we want to avoid it, it is going to happen. But the way people express conflict is deeply cultural. I do believe that. So in India, communication can be more contextual and more relationship driven. That is to say, if let's say we talk about a mediation in a family matter setting, right? You would have to take into consideration the hierarchies, the family dynamics, right? Or the cultural background of the family that you're dealing with. So, in that manner, hierarchy, family dynamics, organizational culture, and long term relationships often play a very larger role in decision making in India. And another thing that I've noticed is parties are quite reluctant to express disagreements openly, particularly in the presence of someone who is superior to them or is an authoritative figure at their work. In the UK, on the other hand, parties generally communicate more directly and place significant emphasis on the process structures and individual autonomy for that matter, right? Participants often expect to articulate their own interests clearly and then engage in relations linearly and focused more on rights and outcomes rather than the hierarchies and the other contextual uh, circumstances that may be present. So as a mediator, then this means adapting the process rather than expecting participation, rather than expecting the participants to adapt to a single model of mediation. So sometimes this involves spending more time building trust and discussing substantive issues. On the other hand, or at other times, it means creating opportunities for the speakers to speak more freely. This could also mean encouraging them to speak either privately or ensuring that individuals who may be constrained by such hierarchies can communicate their interests freely. So then it is upon you as a mediator to mold the whole mediation in such a way that uh, everyone feels comfortable whenever they're expressing their interests or their positions, as the case may be. And to do that, you need to ensure that you have built a sufficient level of trust with them before you have started discussing the substantive issues. Now, ultimately, the whole cultural competence in mediation is not about stereotypes. It is more about curiosity, right? The mediator's role is then to understand how the parties communicate, what values they hold, and what uh, preserving dignity means for them. And I believe that is where you can find a common ground in such situations.
Okay,
Right?
thank you for
I,
that. answer. It was really nice to know that how mediators adapt to the environment rather than parties adapting to the environment as well. The next question for you is, through your environmental and human rights work with Craig, how can ADR be utilized to build understanding in public disputes, whether the power dynamics between parties are drastically unequal?
right. So my work at Craig has reinforced that public disputes involving environmental law issues or human rights issues are rarely just about legal disagreements, right? They're more about, uh, uh, a dispute about their identity. Or if let's say we talk about um, someone coming from a tribe, if let's say we talk about a tribal community fighting for their forest rights, right? It is more about uh, what their identity is rather than just a legal disagreement. So traditional litigation, while it remains essential, particularly when you are to protect fundamental rights or you are to require accountability from the government or corporations, ADR, however, I believe, can complement these mechanisms by creating spaces for dialogue that courts alone cannot really provide. The challenge in that case is, of course, power imbalance, right? Because a community affected by, let's say, environmental harm may be negotiating with a corporation on the other hand, or an MNC on the other hand, right? Or a government body that has significantly greater resources or influence over that particular area, right? In those situations, neutrality alone is not enough. Procedural fairness then becomes critical. This means ensuring access to independent experts first. Second, providing adequate time and resources for the community to participate. Because if, let's say, we're not giving them the resources or the time to participate, then their participation is not really effective or not really useful, right? Now, this also includes using inclusive language and designing processes that genuinely amplify the marginal voices. It may involve allowing community, representatives or technical experts or civil society organizations to participate. Now, successful ADR in public disputes, in my opinion, should not merely aim for a settlement. I think it should aim for an informed participation. I think it should aim for uh, recognition, recognition of lived experiences and solutions that both the parties perceive as sustainable and legitimate. Now, I do think that whenever if ADR does come into play here, if it is designed thoughtfully, it can transform these public disputes from a zero sum context into opportunities and long term solutions. So I do think that is somewhere we can contribute. But then again, one big challenge that still remains is obtaining a neutral ground to start at.
Yeah. Thank you for your answer. Though I get to know more that areas still have a lot of scope of more knowing about people as well. So the next question is for you is you frequently teach on the intersection of courts and arbitration. And how can judicial intervention act as a tool for harmony and resolution rather than a disruption for party and autonomy?
Right. So this is a very interesting one, and this I think has to do a lot with what the future of arbitration in India looks like, right? Because we stand at a stage where confidence in party autonomy, because of the intervention of or the level of intervention that the courts are allowed to make in an arbitration, stands at, right? So I will refrain from taking any either taking India as an example or UK as an example as to what the standard should be, but rather I'll just speak from what my experiences have been with regards to party autonomy and the interference of courts. I think the relationship between courts and arbitration is often framed as a tension between judicial oversight and party autonomy. Rather, I think now the time should be to see it as a partnership. To expand on that, party autonomy is, we all know that it is the foundation of an arbitration, right? But to think about it, autonomy can only function if there is a framework of, fairness around it, enforceability or legitimacy around it. So I do think while party autonomy is the foundation of an arbitration, courts play a very important role in supporting that foundation, right? In creating that equitable framework. So judicial intervention is very effective and I think would be the most effective tool if it is limited and when it is limited to only principled and predictable approaches. So courts should only intervene in, let's say, with enforcement of an agreement, right? Grant of an interim measure wherever it is required and if it is urgent to do so, or for appointment of arbitrators where the parties cannot agree, or for ensuring that due process standards are upheld, right? However, equally important is judicial restraint. Why? Because courts should resist their temptation to revisit the merits of an arbitral decision simply because they have reached a different conclusion than what the arbitrators would have. Right? Because when courts intervene, this the confidence in the whole arbitral process is at stake. So when courts intervene appropriately, they solidify the confidence in whole arbitration process, right? What the parties would have. And what I do think to some extent India is struggling with today. What if our goal is to make India a hub for arbitration, international arbitration, we need to have more confidence of international players in our arbitral proceedings. So that parties are more willing to choose arbitration when they know that there is a reliable judicial system that can support the whole process without really dominating it. right? And I think that is where the thin line is, and that is where the difference is. And in that sense, courts do not undermine party autonomy, but they should rather safeguard it, because meaningful autonomy is only possible if these conditions are, guaranteed, if there is a supporting framework to the autonomy.
Okay, thank you so much for your answer. I love the insight that how the judiciary and ADR should have a relationship that is based on partnership rather than tension, and how judiciary can play such an important role in ADR mechanism. Now, the next
Thank you.
question for you is, what specific communication strategies do you rely on as a mediator to transition parties from a hostile adversarial stance to a collaborative problem-solving mindset?
Right. So I I do think the first step is recognizing that people in conflict often need more acknowledgement before they are ready to
Mm,
come to the problem solving part of a mediation process, right? So I focus on four communication strategies. And I think these are essential skills to have as a lawyer as well, not only as a mediator, but as a lawyer or as someone who works in legal aid. Because often times than not, you are dealing with people in conflict,
mm,
right? Uh, the first one is active listening. Now, this does not only uh, mean listening about their position, but rather trying to actively figure out what their underlying interests are, what their emotions are, and what concerns are behind driving them to this position that they are at, right?
mm,
Second is reframing. Help parties try to move away from the accusatory language, right, to a more future oriented language. Sorry, if you just give me a second.
yes,
Someone at the door. Just give me a second.
yes.
Hello.
Hello, sir.
So sorry. Do you want me to start this answer again, if that
No, no,
would be
you
more
can
convenient for the
continue.
editing?
You can continue.
Okay. So I'll start with the second point again, right? Because I've forgotten where I left off. So the second point that you need to take into account is reframing. What you need to do is to help parties move away from accusatory language to a more future or solution oriented language. To give you an example of this, sometimes the parties may sound like they may say something like they never expected or respected our agreement, right? They never met with our expectations that were there. Now this sentence can become, we need a clearer process for managing what our expectations are going forward in the future, right? So this then helps the parties uh, sort of move away from the accusations that are there and sort of move towards finding a solution or coming to the goal of a mediation process, right? Third thing could be separating people from the problem, right? In a conflict, it is very common for a conflict to become personalized, but we need to realize that solutions emerge only after parties focus on the issue rather than assigning blame on someone, right? Because a lot of times, and even in our personal situations, you would notice that sometimes what's done is done,
Mm,
right? You can't just keep blaming someone for what they've done. Rather, if you want to preserve a relationship with someone, you need to figure out how do you then move forward, right? What do you do about what has been done? Fourth point I would say would be reality testing. Now, I encourage parties to consider the practical considerations of different options, right? This includes cost, be it financial or emotional costs, right? Uh, if let's say they're not reaching an agreement. Now, sometimes reality testing then becomes important because you need to, let's say you're in a dispute with someone, right? Uh, and at the moment, right, it seems like you cannot reach, a settlement with them. Then maybe sometimes you need to step away from the situation and put things in a perspective and see what the outcomes would be. If, let's say, you were to enter into a litigation with them over that dispute, what is it going to cost you financially? What is it going to cost you emotionally? Because let's be honest, as lawyers, we know that a litigation is not just a financial drain, right? It is a very, it can be very emotionally toll taking as well. So, mediator's role is not to persuade the parties to agree, it is to create the conditions in which productive communication becomes possible, right? And that is another important thing to remember. Our goal is not to persuade anyone to agree or suggest solution. It is only to create conditions where the parties amongst themselves can think of solutions, right?
Okay,
And that's all. Thank
answer, sir. The four important things that you mentioned, it's really important to have that in mediation, but as a lawyer in litigation as well, it is quite important to have that thing in relied in our day-to-day legal lives. For those who are currently navigating law school advocacy and moot court competitions, how do we balance the aggressive communication often rewarded in litigation with the empathetic communication required to succeed in ADR?
you. Right. Being a litigator myself, I am a little biased towards not using the word aggressive communication. I would call it rather advocating persuasively. Right. So what mooting and litigation teaches us, it teaches us to advocate for our rights very persuasively.
Mm,
That means you identify the weaknesses and opposing, and then defend your client's position, be it very rigorously if you may. But those are the valuable skills that you are taught in litigation and mooting, right? ADR, on the other hand, requires uh, different but equally important set of skills. So instead of asking, how do I win this argument? You ask yourself, how do I solve this problem in a way that addresses interests of all the parties that are involved, right? Because only then you can reach a solution
mm,
in an ADR. So I do think law students now would need to know how to do both. They should know when to advance their legal position, but at the same time, they should know when to shift into, sort of a listening mode that uncovers opportunities that may be there for resolution. So for students, I would recommend developing three habits. First is ask as many questions. In fact, ask more questions than you think you may need to, right? Second, practice summarizing the other side's perspective fairly. And that is the key word here, fairly, before you're going to be responding to that. And thirdly, learn to separate interests from positions, right? A position and an interest may be completely different things.
mm,
Now, empathy is a key skill here that I think all lawyers should have, and it is one of the most brilliant skills any lawyer can have. Empathy in an ADR does not mean, however, it is often confused for abandoning your client's interests, and that is what you know I try to explain that empathy in ADR does not mean you have to abandon your client's interests. It means understanding the other side's motivations as well, or constraints or priorities, so that you can design a better solution. So, in today's legal landscape, I do think clients increasingly value lawyers who can resolve their disputes effectively and preserve relations wherever it is possible or wherever it is necessary to do so. And the future does belong to the lawyers who can combine these skills of, a litigant, a litigator, with those skills of a mediator, right, or a negotiator for that matter.
Thank you, sir. Your insight was really helpful for me as well, being a second year law student. I would definitely try to bridge the gap between the two of us. Now,
I'm really glad.
before we conclude, what one piece of advice would you offer to young and emerging lawyers?
Hmm. Uh, to young lawyers or law students, one piece of advice. Uh, right. Outside of ADR, I do think you need to be curious, right? Try everything that you can. Make mistakes. And uh, if you were to ask me, one biggest piece of advice, if I could ever give to my younger self, is I would say, make time for yourself. See, once you enter this profession, it is a profession where, you would see people still practicing at the age of 90,
Mm.
right, and above that. So, practice per se is a career which will never end. Unfortunately, you cannot retire from it. So, I do think, everything will happen at its own pace, at its own time. And everyone's journey is unique. Do not compare your journey to someone else's. And I would say take your time with everything and give yourself time to explore, right?
Thank you
So
so
that
much.
is something. Okay, perfect. Thank you so much for your time today, and I really enjoyed our conversations. It really, took me back to my experiences in the UK as well.
I also
Thank
did
you.
enjoy our conversation, sir. You were very insightful. I learned a lot from you today. So thank you so
Um,
much for joining us and sharing your insights so generously. You have shown us that bridging mediation into the courtroom does more than just close cases. It fundamentally changes how justice is delivered and felt.
yeah,
Really, truly grateful for your time and your continued contribution to advancing dispute resolution.
thank you. Thank you so much for
And
having me. It was a
yeah, and to our listeners, thank you for tuning in to me, Arcone Queing. We hope this episode sparked some new ideas about the power of dialogue and the future of collaborative justice. Thank you so much, sir.